The last two procedures we're going to look at are those of the project neutral and the initial decision maker. The project neutral shares characteristics with both the initial decision maker and the dispute review board, and the initial decision maker is in some respects a sort of project neutral established by a specific set of industry standard documents. So let's first look at the project neutral. Very general definition. It's basically a single DRB. It is one person who is competent in the subject matter and the facilitation and decision-making skills assigned to the project or a portion of the project for its entirety for the purpose of guiding the parties through the dispute resolution process. There are many, many other definitions and expectations of a project neutral. So if parties are considering this, they need to be on the same page about what their intent is. A single project neutral is generally used on a smaller project, but one where they expect there will be a fair amount of disputes that can be resolved easily with a little independent guidance. Key considerations, substantially similar to what we've seen before. When parties are adopting this procedure, they need to clearly identify the role of the project neutral for the specific project, the scope of authority, what sort of claims can this person hear, what sort of claims are excluded, and where does the authority come from. Also, ever important, the appointment, challenge, and replacement process. How are the parties going to appoint someone? Are they going to appoint that person first and then with that person develop operating guidelines and scope of the neutral service as is done in a DRB, or are they going to create those terms first and then find someone to fill the role? Obviously, terms of payment also have to be covered. A note on the appointment and challenge process. The three-party agreement that is used in DRBs usually states that a single member of the board cannot be removed unless both parties agree. That same premise should be used if using a single project neutral. But what is often left out of that process is a quick way to replace the neutral and avoid someone using removal of a board member or removal of a single project neutral as a way to change the dispute resolution process midstream. It can very simply be having the candidates that were vetted at the beginning, having a few of them on a reserve. They don't even need to know that. If you do that, though, you have to be cognizant of the fact that they may no longer have the availability to serve for the life of a project. Or this is where those ADR service providers, AAA, JM, CPR, come in very handy. The parties can simply write in that if there is a challenge to the neutral's continued service, or you have to consider that sometimes the neutral, him or herself, may need to step down, that the parties will use a replacement process through one of the ADR providers, and those usually have time limits. And they can be established in advance and put right in the project documents. That prevents a party from using removal of a project neutral, or in the case of a DRB, a single DRB member, as a means to bring the dispute resolution process to a halt and resort to those options at the far red end of the triangle. Now let's move on to the initial decision maker. Prior to 2007, the architect was established in the AIA standard form documents as the first level of review. In the revised 2007 documents, the AIA introduced the concept that the initial decision could be made by the project architect, or if the parties agreed, an independent neutral party. And that has redefined the term IDM. Like many of the other procedures, it promotes early resolution of claims. There is usually some limit established by the contract documents with regard to the scope of claims that can be put forward to the initial decision maker, regardless of whether it's the architect or someone else. The use of an IDM is a condition precedent to going to any other step in the arbitration process. The AIA documents outline using the IDM and then mediation and then arbitration. The AIA contract documents also establish a period of time for the submission of a claim to the IDM. If the IDM does not act on that claim within 30 days of its receipt, the parties no longer have to use the IDM procedure and may proceed directly to mediation. But if a claim is properly received, the IDM moves forward and has several choices. The IDM can request additional information, and this can be from one or both parties, or the IDM can require that an expert be brought in to provide the supplemental information. The IDM can reject the claim in whole or in part, can accept the claim, can suggest a compromise, and the final option, and this is rarely used, but the IDM can advise that he or she does not have sufficient information or that would not be in the best interest of the project for the IDM to make the decision. The IDM's decision itself must be in writing. It must provide a rationale for the recommendation, and if the IDM is not the project architect, the IDM must provide notice of any changes in the contract sum or the contract time as a result of the decision it's making. If neither party objects to the IDM's decision within 30 days of its date, then it becomes final and binding. If, however, within that 30-day period, one of the parties does object, then the IDM's decision is rejected, and there's that time period for one of the parties to insist that the other file for mediation to resolve the claim that's at issue. If the party receiving such a demand for mediation does not comply within 60 days, then the contract documents state that the mediation requirement is waived. If that is the situation and the mediation requirement is waived and the parties proceed directly to arbitration or in some cases litigation, the status of the IDM's decision becomes in question. Is that admissible in those further proceedings? It usually is, but as an advisory opinion only. It is not binding on an arbitrator or a court. And a final note on IDMs, the contract documents do not get into the level of detail we have seen in a lot of other procedures. So things like the selection and replacement of an IDM are not covered. Many of the providers have now filled in that blank, and their procedures for using IDMs can be filled in to make the contract drafting process very easy. So review the AIA document and review the ADR procedures available from AAA with regard to IDMs, and understand that this is yet another variation on a first level dispute resolution process. If anything, it at least provides the parties with another avenue to have an independent decision maker look at the dispute, provide some input, and they can continue their negotiations and hopefully not need to reach the far end of the scale. These are just 4 of the other types of dispute resolution that can be used to resolve construction disputes. There are several others like mini trials, early neutral evaluation, fact-finding, which are used on occasion, but not with much frequency. And we'll include some materials later in the course so you have information in detail on those procedures. But you should be familiar with the IDM, the single neutral, the DRB, and the partnering procedures as they are utilized fairly widely throughout the construction industry.